welcome to another episode of Insider's Guide to the Law. I am your host, attorney Melissa Levine-Pirro, and owner of Levine-Pirro Law in Maynard, Massachusetts. Each month we bring to you legal experts to talk about various issues in the law. While we can't give you specific legal advice, we do our best to bring you general information. If you have specific questions, feel free to email them to us or mail them in at the end of the show, and we'll do our best to answer those questions on next month's episode. So with me today is attorney Julie Franklin of Affordable Law Group. Julie's here to talk about bankruptcy. So welcome to the show, Julie.
Thank you for having me, Melissa.
Oh, you're welcome. So Julie, what are the three big types of bankruptcies?
So, Melissa, there are many different bankruptcies, but the ones that are specifically relevant to the average individual are going to be the Chapter 7 bankruptcy, the Chapter 13, and the Chapter 11. Chapter 11 is not really used as often as the Chapter 7 and 13 might be. In the Chapter 11 context, you need to have $1.3 million in unsecured debt. And when we talk about secured debt, we're talking about debt that is secured by a note or a mortgage. So in the case of your auto loan, your vehicle is secured by that auto loan, or in the case of your mortgage with your primary residence, that primary residence is secured by the mortgage. So those are deemed secured debts, all right? And then we have priority debts, which are those debts that are to taxing authorities, the various entities, whether it's child support, domestic support obligations in general, things that you aren't going to be able to get out of. Those are priority debts. And then last but not least is the unsecured debt, which is a personal line of credit or a credit card. Those would be unsecured. So when I say a Chapter 11 requires the 1.3 million in unsecured, not very many people have those problems. So that's actually why we sort of look towards the 7 or the 13.
And can you just briefly explain the differences between a 7-11 and a 13?
Absolutely. So I like to actually go back to the beginning of America in general and the founders in order to give people a perspective of bankruptcy. So before America really began, right, we had a couple of different options for those pilgrims in England with respect to debt. You could, sort of indenture your child into servitude. You could go to jail. There's various, medieval ways of dealing with this debt. But ultimately, when the founders came to America, they said, you know what? This isn't working for us. Bad debt is a part of an economy. And in order to sort of alleviate the stress of having that bad debt, we're going to create something called bankruptcy. We're going to give everybody the ability to sort of discharge those debts without going to prison or without having to sell your kid. So
seems like a good idea.
It was. And fast forward now to 2015, we've gone through many different versions of what we call the bankruptcy code. And so when we actually say chapter, we're referring to a chapter in that code. So a Chapter 7 is going to be a straight liquidation, alley and free. I raise my hand, I cannot pay the obligations that I am currently contractually obligated to pay. I do not make enough money or have enough assets to liquidate in order to pay those creditors. And for that reason, the Chapter 7 voluntary petition would be a good idea for somebody in that situation where you don't have, mortgage debt that you owe in the form of past due balances. If you don't have big tax debt that you owe, you just have a lot of credit cards and you're finding yourself swimming in these minimum payments, and you keep seeing that balance go up. That's what we call negative amortization. And it effectively means that when you are doing a minimum payment scenario with big balances on credit cards, you're not really getting to the principal balance. You're basically just paying the credit card company an interest amount.
And just treading water.
Treading water is exactly. So when you find yourself unable to open mail because you just can't tread water anymore, you need to look to a Chapter 7. A Chapter 7, and all bankruptcy is really designed to give an individual a fresh start. To say, you know what, we need to reset the clock. This is not working. We want to give you a chance to have better habits, to get back on your feet, to make life work in a way that it isn't working for you currently.
And what about a Chapter 13?
So a Chapter 13, and again, we're talking about Chapter 13 in the Bankruptcy Code. And a Chapter 13 is a workers' plan of reorganization. So these would be the individuals who owe, 5 to 6 months on their mortgage payments, maybe even up to 2 years. We really, as bankruptcy attorneys, we're pretty judgment-free. We've seen a lot of messes that people get into for various reasons. And to be completely honest with you, Melissa, health is a major concern. A death in the family where you've lost substantial income relating to a person that was in your household and was contributing, or a situation where you're unemployed for a period of years. All of that stuff tends to add up when you can't, for whatever the reason, pay the maker. So those debts and that situation, that's why we see a lot of the bankruptcies that we do see. Yeah. But the Chapter 13, rather than liquidating, because in a liquidation, you explain to the individuals that you are currently contractually obligated to pay. Either I can pay you and I'm going to keep this, and I'm going to keep paying it as agreed, or I'm not paying it and I can't keep this, and I'm going to disavow the contract in my Chapter 7. In a Chapter 13, you are limited in the sense that you are not going to be intending or stating your intent specifically with respect to a contract. You create a Chapter 13 plan. And in that Chapter 13 plan, you explain to creditors, this is what we're doing. This is how this is going to happen. So in that Chapter 13, and I should mention that with respect to the Chapter 7 or a Chapter 13. So in 2005, Congress actually revised the Bankruptcy Code and made it a little bit more difficult for people to file that Chapter 7. A Chapter 7 takes really anywhere from 5 to indefinite months, right? But if there's no major complications and if the court isn't incredibly bogged down, you can probably get in and out of a Chapter 7 in around 8 months. And that is not the case for the Chapter 13. The Chapter 7 is really based upon your income. So if you're a single guy in Massachusetts and you're making $150,000 and you want to file a Chapter 7, the court's going to ask you why. Why are you making so much money? And why can't you afford to pay your creditors? Right. And for that individual, unfortunately, a Chapter 7 is probably not going to be available to them. They're going to be forced into a Chapter 13, which is that workers' plan of reorganization, which says, you make over a certain amount of money, or you have elected to pay certain creditors because of the things that you want to keep. And that plan lasts anywhere from 3 to 5 years. And based upon your income, you're either in a 3-year plan or a 5-year plan, and also the amount of liabilities that you're intending to pay throughout that plan. So if you've got $40,000 in mortgage arrears and a $10,000 tax liability, well, $50,000, depending on your income, over a 5-year plan, you may want to go into the full 5 years so that you can give yourself the full amount of time to pay that off. But that is the trick with the Chapter 13, that you don't get more time. So if you can't produce a feasible Chapter 13 plan to the court, to the trustee, and to your creditors that indicates that you will be able to pay the liabilities that you are not current on in that 5-year plan, that is not feasible. And so you're going to have to go back to the drawing board to figure out a more, sort of copacetic solution to what your debt structure is and what your problems are in that area.
And so are businesses allowed to file?
They are actually. The Chapter 7 for the business is sort of an interesting solution to a business that is winding down. So businesses have a tendency to contract as individuals do. And once a business has sort of died, so to speak, normally the business just dissolves. in accordance with the state procedures that require a business to dissolve. But in the case where that business might have dissolved, but there are still creditors coming after the principals or still coming after the name,
Right.
a Chapter 7 liquidation for a business is sometimes the best way to formally communicate to everyone involved that, you know what, this business is out and we are done. We have liquidated. We have no more assets. The assets on our schedules are the only things that we have. And that allows the trustee, through trustee process, to come in and distribute them among the creditors accordingly. But unlike an individual, and we haven't really touched upon this yet, that fresh start that I was talking about earlier, and sort of being free from these debts and getting better habits.
Yep.
That is effectuated by the federal bankruptcy court's order of a discharge for that individual. So in the case of an individual's bankruptcy, if everything, all the boxes are checked, everything's done properly, everything's been disclosed, and the trustee does in fact find you to be someone that is to be given that discharge, they will file a report with the court. The court will enter an order of discharge. That discharge effectively discharges you from all of those liabilities to the extent that you have elected to be discharged, or that
Right.
they haven't been disputed, or that they're not priority debts, because sometimes you can't get out of taxes
Right.
or student loans, for example. You are never allowed to get out of student loans in bankruptcy. We're hoping, but there's nothing in sight just yet.
I think that would cause a lot of people to go running to the bankruptcy courts if that ever
Exactly.
changes.
Exactly. But the discharge that is offered to that individual, that's not offered to a corporation. A corporation is not entitled to a discharge because they don't get that fresh start that a citizen might. So in a Chapter 7 context for a business, it's a good way to say, hey, here are some funeral proceedings. This is what's happening, and we don't want a discharge, but this is all we have, and we're here to die, so to
Right.
speak. And so that's what the Chapter 7 does for a business. In the context of business bankruptcy generally, we often see businesses file Chapter 11s, which is also a reorganization plan, but that's a different structure of reorganization. You have a creditors committee, and there are many individuals that are in Boston that are far more well-versed in the ins and outs of Chapter 11. And for our audience, I would hate to embark upon a Chapter 11 scenario. If you believe that you have a $1.3 million unsecured debt problem, I would encourage you to consult a Chapter 11 bankruptcy attorney.
And I think we're talking more big businesses too for
Exactly.
that. I mean, it comes up a lot in the news right now because Donald Trump had filed multiple Chapter 11s for his businesses.
That's exactly right.
So I think that's not really our viewer audience, as you said. But what is our viewer audience is probably people with a lot of unsecured debt. There's a stigma about filing for bankruptcy, unnecessarily so. I mean, I've seen statistics that bankruptcy is as prevalent as divorce. The difference is people don't talk about it.
Exactly. And that's a really interesting element of being a bankruptcy attorney, because you often bankruptcy attorneys have a different referral network. Nobody's going to talk about it at a cookout, so
Right.
to speak. Hey, I filed bankruptcy with this guy and it was amazing and I feel so much better. A lot of my clients are in a position where they've hit it. They've hit rock bottom, and they're tired of looking at mail that they can't do anything about, and they're getting sued. A big part of the Chapter 7 crowd is the individuals that continue to get hit with lawsuits and just realize they cannot handle all of them.
So let's just talk about that briefly, because you raise a point. Aside from the people who can't pay their bills or just paying on the interest and not the principal, bankruptcies are a tool when you get sued.
Exactly. So if you have, and I think of them as fires. So you have a lot of fires that you need to put out. So
Yes.
there may be somebody suing you on a credit card balance you forgot about in a district court in another county. And then you get a notice a couple of months later from another court, and they're also suing you, and you're getting overwhelmed, and there's lots of paperwork that you're receiving that you need to act on, but like everything else in your mail, you just haven't gotten to it. And it's really the psychology of filing bankruptcy. And I am 5 hours short of my medical degree, but it really is, you get into a phase where you just are in denial about your financial status. If you, and I say the litmus test is either lawsuits or not being able to make more than your minimum payment on your credit cards. Because again, as we talked about earlier, making that minimum payment does you no favors. And
Right.
if you don't have enough money in your bank account to pay those creditors a significant portion of their balance on that monthly statement, and you've got 5 or 7 of those, you need to contact a bankruptcy attorney. Because, and we're not saying to use this tool as a magic eraser. It's not. You only get to file every so often, and by every so often, 8 years. You can't get a discharge in some cases if you've previously gotten a discharge in years prior. So it's not a magic eraser. But for those individuals that really have just gotten into a hole that they cannot crawl out of, bankruptcy is a relief. And a majority of my clients, at the end of it, they say exactly that to me. You know what? This has been such a relief. And I am so grateful that this is now off my shoulders and that I can move forward. And so I encourage anybody who's in a situation where they just feel like the situation itself is insurmountable and it's too difficult to tackle, so I'm just not going to touch it at all. That, you know, it's kind of like the fight or flight mentality. Just because we think that that's our gut reaction doesn't necessarily mean that that should be what we do. And
Yeah.
and honestly, for those individuals, burying this stuff by not talking about it, by not opening that mail, by not making those payments, by changing your phone number so you're not getting collection calls, that may alleviate the problem in short term, but in long term, it really hurts you in a significant way. And it is much easier to at least address the problem head on, to find out what your options are, you know, and make that first phone call in a way that you can actually potentially change the trajectory of your financial future. Because that's what bankruptcy is designed to do. To say, look, you messed up once, no harm, no foul. Let's get it right the second time so that you can get back on your feet and that you can pay for stuff that you need and maybe not buy the stuff that you don't.
Yeah. So for our viewers at home, I'm guessing most of them would need to go into a 7 or a 13. So maybe you could just walk us through the process a little, what to expect, what they need to do, any preemptive measures they can take.
So with respect to who might want to file that Chapter 7, again, we're talking about people that are being sued in many different courts. We're talking about people with high credit card balances who have low monthly income and really can't afford to make those balances go away in any real way over time. And the elderly, actually. So there are a number of individuals, you know, when you retire, you run out of things to do, per se. And sometimes you find yourself on TV and you are just buying things and it works out great for the first couple of months, and then you get that bill. And that bill is a crazy thing that you did not anticipate having to pay, or you thought you could pay because it sounded like a really good deal, but in actuality, it isn't. And, you know, those individuals, they tend to continue to do this over time. So when you're talking about estate planning, when you're talking about, you know, with respect to things that an estate administrator might have to pay through the estate after death, those credit cards are the first thing that they have to pay, you know, among others. And if you could eliminate those so that that's not an expense of the estate before it comes to that, that really we have found to be also a great tool, because it really just, you know, these are situations where people are entitled to a fresh start. And it may be, you know, a retired individual who has always had a great income, you know, but finds that income reduced because of retirement.
Right.
And just, you know, ultimately ends up, again, in that proverbial hole. We're talking about just a situation where you can't get out. Call a bankruptcy attorney. That is the best advice that I can give you, because even if you don't qualify, you're going to learn some interesting information that will be helpful going forward.
And so what does the process look at? Like, can you explain, automatic stays, 341 meetings,
Absolutely.
paperwork?
So I tell my clients that, so when you file bankruptcy, and I mean, when you file bankruptcy for the first time, let's say, and you do it properly, because there are many contingencies, obviously, with any individual. I can't speak specifically to the individuals in our audience, but when you file a bankruptcy from the date that you file, okay, to the date that that bankruptcy ends, you are protected by the federal automatic stay. And I tell my clients that the federal automatic stay is kind of like a force field. It sits over you and your assets for the duration of the time that you're in bankruptcy. So we were talking about those fires in different courts, all right? That automatic stay functionally puts out all of those fires. Yep. So that those individuals, once they receive notice of your bankruptcy filing, are required to come into bankruptcy court to assert their claims against your estate. Mm-hmm. Now, as I said earlier in passing, but we'll reiterate right now, things that this won't stop: criminal proceedings, family court proceedings, proceedings involving basically any sort of obligation over and above a monetary obligation. So, those child support, court proceedings or alimony, that is not stayed by the federal automatic stay. But everything else, for the most part, is. And of course, if you have a creditor, let's say that you are facing foreclosure and you have not been able to successfully negotiate a loan modification, or you're in a position where a loan modification is just not feasible, and you owe, many thousands of dollars on that mortgage, that does not prevent a creditor from coming into the bankruptcy to move for relief against the property from that stay. And that is a motion that a creditor can bring, and a bankruptcy judge can rule in their favor and give them that relief. But absent that motion for relief, your assets are protected, because this is a part of the bankruptcy proceeding.
So really, once you file and that automatic stay goes into effect, you can kind of take a sigh of relief. The creditors will stop calling, all of that,
Well, and just with respect to even retaining a bankruptcy attorney. So if you're in a situation where you are dodging phone calls, getting tons of voicemails from people that, want a piece of you, when you retain a bankruptcy attorney, you get to tell those creditors to call your bankruptcy attorney. So that is automatic relief in a way that, is eventually also effectuated by the filing of that bankruptcy. But while you are gathering your documents and pulling your information together to put into your voluntary petition,
your attorney's like your buffer zone.
Your attorney is your buffer zone. And so you automatically, as soon as you have retained an attorney to file you, get to send those creditors somewhere else. And for my clients, that is the immediate relief that they didn't even know that they wanted, and then are ultimately so grateful to have. And then going back to the process in general. So with those revisions to the bankruptcy code in 2005, we are now required to file financial management courses, certificates that you have completed this financial management course. And the financial management course is offered through various companies. You have to file a certificate before you file, or with your actual petition documents when you first file. So you have to complete a course before you get to the filing. And it takes anywhere from 30 minutes to an hour. And it's just a brief overview of what you have going on. What are your debts? What are your obligations? Do you have anything out that you could liquidate to pay? If you don't have anything that you can liquidate, how can we build better habits? So once you complete that course, and you do it on your own, you can do it by phone, you can do it by internet, you can even, I think there's a booklet, it's offered in several different languages. Then you file your bankruptcy, and you, in approximately 5 weeks from the date that you file, so let's say we file today, and today is September the 1st. So in about 5 weeks, we would get a notice of a 341 meeting, And that 341 meeting is, and again, when I'm using numbers, I'm using numbers that are, assignable to the bankruptcy code. So a 341 meeting is a meeting with the court-appointed trustee who reviews your petition documents to make sure that you're, giving them full disclosure, telling them everything, any property that you own, anybody you could sue, any, baseball cards you've collected that are in your garage. And provided in that 341 meeting, the trustee finds you to be a credible individual who is entitled to that discharge, you get out of that 341 meeting, you have to complete a second course, which is 2 hours. And that is even further of an in-depth overview about how to establish better credit habits. And then you wait. And after you file that counseling course in a few weeks or months, depending on just, the volume in the bankruptcy court at the time, if they find you to be one such individual that does qualify for that fresh start, the bankruptcy court will issue an order of discharge, and you will be in the money and on your way to that fresh start.
Well, thank you, Julie. I think that's a lot of information for our viewers at home about bankruptcy. I hope everyone will join us again next month for another episode of Insider's Guide to the Law.